Yes.
All right. Hello, and welcome to another Nevada Legal Services live stream. I am Ray Gertkin. I'm the directing attorney of the Reno office of Nevada Legal Servicer. I know, I just said I was the directing attorney, co-litigation director at Nevada Legal Services. And of course, I am joined by David Olshan.
Right. And I'm the co-litigation director. So you got the top brass coming to you live
on our YouTube channel. I know it's been a while since we've been live, but hopefully we have some good information for everyone. Today, we're going to be talking about the new Nevada eviction moratorium and the mediation program. We actually had planned on doing this last week, so our topics are going to be slightly different, but obviously Governor Sisolak instituted a new eviction moratorium in the state of Nevada on Sunday. It went into effect Monday evening. Monday evening or Tuesday evening, I forget. The 15th.
11:59. It was on the 15th.
Yes, on the 15th.
Tuesday at 12:01.
But it is in effect now, and it does cover eviction notices that you may have gotten before the 15th, which we will get into here in a minute.
It takes care of everything. So that time is important because if you have an order, it stops the order.
Right. So just so everyone knows, you can access the governor's directive as well as the declaration that tenants are supposed to fill out by going to the nvhealthresponse.nv.gov site. On our website, you can actually download the tenants declaration as well, and that's nlslaw.net. But we will go ahead and get started. David, do you want to go ahead and get into what the governor's new directive says?
All right, so Directive 36 is broad in its application. And like I said, the time really does matter because if you have an eviction order entered against you, Directive 36 should stop it. It applies to residential dwellings and mobile home parks, even if you own the mobile home. It'll stop any eviction notice or eviction order based on non-payment or no cause. There are certain requirements, and we're going to go into them, but you need to be a covered person. So your inability to pay the rent must be related to COVID-19. Either you lost your job or have decreased hours, or you have medical expenses that cause you to be unable to pay the rent. Also, if you're evicted, you will likely be homeless or have to go into crowded housing. And your income has to be for a single person, basically $100,000 or less in 2020. And for a family, it's $198,000 or less. If you received a stimulus check, that's good enough. You don't have to worry about income. Or if you're not required to report income, you don't have to worry about the income. All right, so if you do qualify under Directive 036, you must provide a declaration to your landlord and each adult member of your household. I believe it's adult member. It wouldn't make sense for a kid to do it, but each member of the household also has to provide that declaration. Even if you supplied a CDC moratorium declaration, you still need to do a Directive 036 declaration because the CDC moratorium ends at the end of this month. Directive 36, the governor's moratorium, ends at the end of March 2021, so it's going to give you a lot more time. Well, let's go back. There is some mischief in this directive. It does allow the landlord to challenge the moratorium, either based on the declaration is false, or that the landlord will suffer a foreclosure as a result of this moratorium. Now, it can't be, oh yes, I'm going to suffer a moratorium. It has to be a complaint for foreclosure. It has to be a notice of default. It has to be some evidence that the landlord is going through a foreclosure, and that would do away with the moratorium.
And I do just want to make sure that we address it, that it does require proof that the foreclosure is actually going to happen during the span of the moratorium. And just for tenants who might not be aware, foreclosure process can take a long time. It's at least 4 months once the notice of default is first recorded. which that might not even be the case at that point in time. So just know that, you are looking for a notice of default that's actually been recorded and that essentially a sale is imminent. I think would really be what you want to argue, that the landlord might be facing foreclosure in the future. We know there's still foreclosure forbearance programs in place until the end of the year as well. But, yes, we don't want landlords to have to go through foreclosure during this crisis, but do be aware that there is a level of proof that is required, both for landlords and tenants, in order to potentially get through a contested hearing.
Right, and the statute has to have some meaning. So if a landlord can simply just say they're in foreclosure, it obviously doesn't work. They have to provide some proof.
And if anybody wants to learn more about the foreclosure process, we do have videos on our YouTube channel that you can check out. And then one final thing I forgot, I wanted to just, sorry if we're pounding this in, the stay does affect anything that's in process. So if you have gotten a lockout order, let's say you got a lockout order on Friday or Monday and it has not been executed yet, you can argue that you should not be locked out, and the sheriff should actually not be executing lockout orders right now. That's actually included in the directive. But if you did get an eviction order and you would like to make sure it's stopped, you can certainly file a motion with the court to ensure that your eviction is stayed. Now, that does mean that the eviction will likely be stayed until the end of March, but you would be able to have that time to figure out what to do.
It's just vital, because people can say, I saw the governor on TV, I'm protected. No, as a tenant, you really need to do something. You need to provide this declaration to your landlord to get this protection. All right, so this is kind of what I talked about. The CDC moratorium ends at the end of December. This new Directive 036 moratorium ends at the end of March. So you will have to execute and deliver to the landlord another declaration. If you have been denied, if you use the CDC moratorium and a court denied it based on a lack of evidence, you're not entitled to this moratorium either. I pointed this out. It's like insurance for a dead person. If your CDC moratorium didn't work, you're probably not a tenant anymore. So, this exception, it probably makes landlords feel good, but it really doesn't amount to anything because you're not going to use it. You've already been evicted. Also keep in mind, unlike other moratoriums, the landlord may charge late fees. So during this time, the landlord can charge late fees, and for any previous time that wasn't covered by a moratorium. I think the previous moratorium was from March to the middle of October. So middle of October to December 15th, yeah, the landlord can charge late fees. And of course, prior to March, whenever the first moratorium took effect. Okay, next slide.
Oh, and I did just want to take a moment to highlight, in case anybody's wondering, how is this different from the CDC moratorium? Just, why it's important, as David said, to give the new declaration to your landlord. One, the CDC moratorium expires at the end of December, but two, there are some differences, and you want to make sure you're covered by both if it's at all possible. This does cover no-cause evictions. I know that was one of the biggest areas of contention, I will say, with the CDC moratorium, was whether or not it covered no-cause evictions. This does make it clear that if you're as long as you're in default of rent, you cannot be evicted if you have a COVID-related loss of income or medical expenses. But if you're in default, no matter, what notice you receive, a no cause or a rent notice, you can't be evicted. Now, of course, it still has an exception. It does not cover nuisance or lease violation notices. So just be careful with that. But no cause evictions are covered. There are no longer requirements to make partial payments or seek rental assistance. But obviously, I want to encourage everyone to continue to seek rental assistance. I don't believe that all of the rental assistance, I know for, in Northern Nevada, the rental assistance has definitely not been exhausted. And there was still a lot of money in Southern Nevada available. So I do still want to encourage everybody to apply for rental assistance, but there is no longer a requirement that you have to seek it.
And Ray, I think we both know that, there is the rental assistance, but sometimes they have trouble processing it. So like unemployment benefits, you have to show a lot of patience. But yes, rent will come due at some point. So you should try to seek that rental assistance.
And that is still something that if you're requesting, and we're going to talk about the mediation program, if you're requesting mediation, you also need to still continue to request the rental assistance. And then the default in the rent is still tied to COVID. So we are, we're getting back to the point being that COVID has affected you. I kind of have a beef with some of this because I think you can do both, protect community spread and help people who have been impacted by the coronavirus. But one thing that you're missing when you tie everything to COVID is literally just if somebody wants to issue a no cause notice, they can still do that. And you can be evicted if you don't move. It really is tied to a default in rent because of COVID. Otherwise, they're very similar, as we've discussed. You need to submit a declaration to your landlord, and you need to allege the information that we've talked about.
All right. So if Directive 036 does not apply, it's very likely what you just talked about, Ray, that the inability to pay rent is not related to COVID. The thing is, I think a lot of people should not just give up, because if, for instance, you have a job, you continued with your job during the pandemic and your hours were cut, that's included. And I would suspect that if your hours are cut, it's related to COVID and the employer's inability to keep people on regular hours. And if that's the case, you are affected by COVID. So think outside of the box, think creatively. And there are ways that you go to the doctor if you're sick. Those bills and your inability to pay rent, that's related to COVID. So it's simply not losing your job, not being able to go to your job because of COVID. There's much more circumstances that relate to COVID. But yes, if the CDC moratorium doesn't help and Directive 036 doesn't help, look, you can still file these things. They wouldn't be based, they wouldn't be truthful, they wouldn't, the rules wouldn't apply, but you could still do this stuff. You can still seek mediation help too.
Yes. One thing, we're going to talk about mediation next, but one of the other parts about the mediation program is that the rules don't specifically limit the mediation program to only COVID-related rental evictions. But because the CARES Act is the money behind the mediation program, people are required to certify that they had a coronavirus-related impact in order to have a mediator for the mediation. But the rules don't limit it. So, we would encourage anyone who is facing a non-payment of rent action to still request mediation, and potentially could be a defense in court if it's not granted. And again, as David said, I definitely encourage people to not think in the limited, well, I'm still working, so how am I affected by coronavirus? Well, I mean, he's right. If your hours were cut, whatever the case may be, if it is, if the coronavirus was part of the world that you're living in, it could have a coronavirus related effect.
And I think the broadest sort of circumstances when the schools are closed or have remote learning and you have to stay home as a parent, that's COVID related.
Right. All right, so just to kind of go over the procedure for the eviction process as we get into talking about the mediation program, we are generally talking about a 7-day pay rent or quit notice. As we've said, a no cause notice also is covered by the moratorium, and that could be a 7 or 30-day notice. But essentially, once you get the 7-day pay rent or quit notice, the tenant needs to be proactive. You need to first, if you haven't done so already, get that declaration to your landlord. In order to contest the eviction and request mediation, you need to file a tenant's affidavit with the justice court. So that tenant's affidavit is your defense of the eviction, but also your request for mediation. I would definitely, make sure that anybody, if you're filing these, please attach the CDC declaration and the Directive 36 declaration to your tenant's affidavit. Make sure the court knows that you have provided that to your landlord. You do have to file the affidavit within 7 days if we're talking a rent eviction. No cause notices will require a 5-day unlawful detainer notice. So either the 7-day or 5-day notice, make sure you file your tenant's affidavit within that time frame. And then obviously just make sure your mediation request is in that affidavit. And our forms have it. The court form will likely have it as well.
And one thing though, by requesting mediation, you're going to get more time. I mean, there's no doubt you're going to get more time. Even if you don't have anything to mediate, you still will get more time.
Even if you think your landlord's not going to agree to anything, it could be possible that being in front of a mediator is different. Going through a formal process might make things different. So even if your landlord has told you in the past that he's not going to agree to anything, don't let that discourage you from requesting mediation or contesting the eviction. And always make sure, even if your landlord says, oh, don't worry, we'll work something out, please make sure that you're filing these things. Once you get the notice, if you don't file a tenant's affidavit, your landlord can simply ask the court to lock you out. Now, obviously, that can be different if you've given the Directive 36 declaration to your landlord. They are prohibited by the directive from issuing you a notice. So there is still that, and you can file a complaint with the Attorney General's office. But if you do, it's, we do want to make sure that you do pay attention to notices you receive from your landlord.
So this is discusses the state bar rules regarding mediation. And we should talk a little bit about the legislature passed, I think it was SB1 or SB3, SB1, I believe.
SB1, yeah.
Yeah. Basically requiring the Supreme Court to come up with rules. And we're talking about the Supreme Court rules. What the state bar did, they worked in conjunction with the Supreme Court and they couldn't find, whoa. Can you go back?
Oh, yeah.
Automatically.
Sorry, some of them are jumping. I apologize.
Anyway, they couldn't get any mediators, so they used the CARES Act money. And to use the CARES Act money, it has to be related to COVID. So that's how this arose. It's really not in the rules. It's not required, but it is sort of informally required. And the other qualifications here are in the rules. You have to have liquid assets or savings of less than $3,000. You have to, this is not in the rules, but you have to have lost your job because of COVID, now unable to pay rent, or your wages have decreased, or you've been furloughed, or you've experienced a reduction in income. So this COVID part is not in the Supreme Court rules. And so that's why we're saying it's not necessarily a requirement of the program.
But as we know, practical reality is that the CARES Act pays for it. The mediator is going to ask for certification of this information before you're granted a mediation.
And I hope somebody is coming to the conclusion that if the legislature wants to do something, they should do it and not pass it off to the Supreme Court, and the Supreme Court pass it on to the state bar and local jurisdictions. Somebody really needs to show leadership. And nobody did with regard to this mediation. And yes, editorial comments are my own, not approved by the Legal Services Corporation or Nevada Legal Services. All right. Now, this is what I talked about before. You'll get 30 days. You should request mediation. If you want extra time, this is one way to do it.
And it's always obviously good. The agreements will, if you do come to an agreement, it will be reduced to writing. So just know that. Make sure you get that.
Right. People make all kinds of promises to avoid eviction. So, I would encourage people not to do that, but I also understand that you're desperate. And, if an agreement will buy you more time, maybe that's something you're going to do. It is important, as you said before, Ray, to seek rent assistance. Unemployment benefits are kind of out of your hands. So there's problems with the Employment Security Division, but maybe you will get a check and maybe it will help. And that's another reason to not sort of give up hope in these situations, but request mediation, because maybe that, those unemployment benefits will be received and help you pay the rent.
Well, and it's also a way to actually have a discussion with your landlord to tell them, like, I can't get my unemployment benefits. I mean, this is not a secret that the unemployment benefit system is failing a lot of people. So, if you're having trouble communicating with your landlord, this is one avenue to do that.
And this is the tragedy with the Employment Security Division, that, you could be eligible for let's say, $10,000 in unemployment benefits if they would only get their act together. So this could possibly cover the rent arrearage and everyone would be happy, but we have the Employment Security Division gumming this up. And here's a little promotion. Next Tuesday, we're going to talk about unemployment benefits.
Right. And that's Tuesday at noon right here. The status of pandemic unemployment assistance, which I don't even know what we're going to talk about because it's all over the place.
Okay, so this is one of my sort of pet peeves, is that a lot of people like Governor Sisolak are kicking the can down the road. So you have to pay the rent at some point. And if you just say, well, we're going to put it off until March, it still needs to get paid. So, that's something that people need to plan ahead and say, how am I going to be able to pay the rent? If you couldn't afford the rent before the pandemic, you're not going to be able to pay it back. So one of the things you should think about, you can appeal a summary eviction order if it's entered now or if it's entered in April. You have 7 days to pay the rent. If you can't pay it, you'll get a hearing. Perhaps mediation is still around, so you can get 30 days, and you can appeal to get more time. But there is a cost. It's $250 for the bond. And if you don't get the filing fee waived, it's $121. So, you might want to think about other things. And one of the things to think about is a Chapter 7 bankruptcy, because a Chapter 7 bankruptcy would discharge all this rent arrearage, and a landlord could lift the stay and go forward with the eviction. But the point is, you wouldn't owe money at the end of it. So something to keep in mind: if you're evicted and you owe the rent, the landlord can come after you for the back rent, can send it to a collection agency. It could haunt you for a long time. So, think about what you want to do. If you have money to pay the rent, if you want to go for rent assistance, try to plan this out, because rent will have to be paid at some point.
And, one of my, I won't use the words I've described it, but just also remember, in order to avail yourself of the moratorium, you have to be in default of rent. So we're already in the default realm. So what David is really talking about is planning ahead for what happens when the moratorium ends.
It's a tragedy too, when you see someone struggling to pay the rent and dealing with a landlord who will not take, no for an answer, and they have no money for food or anything else. They've just been struggling to pay the rent. So all these protections don't really help. And that's, to me, one of the worst situations.
Yeah, it's my biggest problem with this is if somebody has actually been struggling to get the rent paid, you can still be evicted even on a no-cause notice. So just everyone keep that in mind. But that does it for our presentation. Please feel free to leave a comment. If you guys have a question, we'll stay on for another minute or so. I do not see any questions at this point, but if you do have something you would like us to address or are confused about something, please feel free to let us know. But thank you for attending. And as David said, we are having another live stream next Tuesday to talk about unemployment benefits. So feel free to also join us then. But David, any last final thoughts?
Yes. It's heartening to see there might be another stimulus bill in Washington. I think that part of that, although they're very tight-lipped, might be an extension of unemployment benefits, $300 per week, plus a stimulus check. So, don't lose hope. There might be help from your elected officials in Washington. And we should hear about that today or tomorrow, because the budget needs to be renewed, and they need to get some work done before the Christmas break.
And I know that the entities that are handling the CARES Act rental assistance have been requesting additional time to get through and process the rental assistance applications. I hope that also is able to get done by the government by the end of the year. So I want to encourage everyone, apply for rental assistance. There are applications that are, they're still taking applications. There's still money left at this point that I'm aware of. So I definitely want to encourage you guys to still, try not to get discouraged and continue requesting any of the information or resources that you can get. But that will do it for us today. Thank you guys very much for joining us, and we will see you next time. Thank you, David.
Thank you, Ray. Tell me when.